All right.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning and welcome, everyone. Madam Court Officer, could you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Nasim Haradinaj.
Thank you. I'd kindly ask the parties to inform us, rather than introducing everybody again, if there's anybody new in your group. Prosecutor, anything?
Good morning, Your Honors. One change from last week from the appearances. Lena Peterson is not in the courtroom today, and in her place is Clemence Vol Maravaldi, Associate Disclosure Officer.
Thank you. Mr. Rees, anybody to add?
Yes, Your Honour. I'm additionally assisted today by Miss Faye Wigmore and Mr. Remy Halilai.
Thank you. Mr. Cadman.
Only one change. Mr. Buckley, who's not with us today, will not be with us tomorrow. And just for the record, Mr. Haradinaj wanted me to convey to the court that whilst he takes no issue with the trial panel, he still has very serious concerns as to the conduct of the prosecutor, and so he is not attending. He's refusing to attend today and tomorrow.
Thank you. I note that Mr. Gucati is in the courtroom today. And we do note for the record that Mr. Haradinaj has waived his right to be present at the hearing. As you all know, last week the panel held the trial preparation conference in this case. We issued a number of oral orders for the next steps. Meanwhile, the panel has issued 2 written decisions, one on its reasons for denying the protective measures requested by the SPO for its witnesses, and one on the Rule 102 sub 3 updated notice. Pursuant to Rule 116, paragraph 2 of the Rules of Preparation, conference for the SPO must be held within 30 days of the trial preparation conference or as directed by the panel. In this case, the panel, after hearing the parties, scheduled this conference within a week of the trial preparation conference for, I think, reasons that we mentioned last week. A written agenda was issued on 6 September 2021, and we will be following that today. It's our hope and our intention to try to finish this conference yet today and not have to use the extra day tomorrow, but it is available if it comes up. Let's start with the first topic on the ongoing issues of disclosure. Mr. Prosecutor, in the past few days, your office disclosed new packages, numbers 42 to 44. The panel understands that packages 43 and 44 are related to the SPO's request to add 1 witness to its list and are subject to a request for adding them on the exhibit list, and we'll get back to that later on. As for package 42, it seems to contain the declaration of an SPO staff member who declares never having said that the documents could be kept by the KLA-WVA for a month. And you, sure, I've been asked to slow down. And you have submitted this under Rule 102, paragraph 3. So we take it that you do not plan to request the addition of this document to your exhibit list. Is that correct?
It is, Your Honor.
All right. Any other or any further disclosures expected before the SPO case should begin?
None are currently anticipated, Your Honor. We are mindful of the Rule 102.3 notice decision from yesterday. We're evaluating our options following that ruling, but otherwise there's no outstanding disclosure anticipated.
Thank you.
Oh, with the one exception of what I mentioned last week already, that there is a pending third-party request. However, it's still pending. We've not received any information.
Right, we understand Does the defense wish to raise any outstanding disclosure issue? Mr. Rees?
Yes, I do, Your Honour. We've obviously received the order of the trial panel yesterday in relation to the Rule 1023 notice, the requirement for a detailed notice dealing with those matters which the Court of Appeal had previously identified as relevant. We will await to see what we receive in relation to that order at the close of play tomorrow. And I think the order requires the redacted Rule 1023 notice in accordance with the confidential annex that was annexed to the order. So I don't say anything more about that as a specific topic, but I do wish to revisit the Rule 1023 notice in its entirety, so not restricted to the matters that were subject to the Court of Appeal's decision, in particular the process by which the information arrived at the KLAWVA premises, but the Rule 1023 notice in general. That notice, of course, is required to list all relevant material in the possession of the prosecutor. I won't go over that issue because the principle is firmly established now, both by the rule of the pretrial judge, confirmed by the Court of Appeal panel, and of course applied by Your Honours in the ruling yesterday. But it does seem to us that there's real concern as to whether the SPO have been applying that principle. Your Honour has just referred to Disclosure 43, for example. Disclosure 43 was made on the 3rd of September 2021. It refers to an interview, witness interview, that took place on the 25th of March 2021, and a series of exhibits produced by that witness during the course of that interview.
Judge Mitro has asked permission to intervene at this point for just a moment.
Of course.
Mr. Rees, just to indicate, I had the same assumption as you as regard the date. It appears it's a mistake on the top of the document. If you look at it, at the next few lines, you will see that it says the 25th of August, and the footer of the same document says the same. So I was under the same apparent misapprehension as you are, but it does seem that it is in fact a record of an interview that took place on the 25th of August. I just wanted to bring that to your attention.
Yes, if it helps for the record, Judge Macho's accounting is correct.
The point remains the same. We had no notice of that until the service of the material on the 3rd of September. I do raise the question whether, in fact, the SBO have properly listed all relevant material under the Rule 1023 notice. The Rule 1023 notice, of course, requires notification of all relevant material as soon as possible, as soon as the material is in the possession of the prosecution. That hasn't been done in this case, and I do urge the SPO to undertake a root and branch review of the material they hold in their possession to see whether there are any outstanding matters that should go on the Rule 1023 notice, in addition to the matters that have been raised in the order dealt with by the trial panel yesterday.
Thank you, Mr. Rees. Mr. Cadman?
Thank you, Your Honour. As with Mr. Rees, I had been prepared to deal with the disclosure issues today, but in light of Your Honour's ruling, we will wait to see what is served by the prosecution. I do share Mr. Rees's concerns, and in particular, one point that we may need to get to at a later stage. It may not be the most appropriate time to deal with it now. But last week, Mr. Halling for the SPO had indicated on a number of occasions that the contact notes with witnesses did not include any interview transcript or any statements taken. In fact, that interviews were not conducted of those witnesses, and there was a general flitting between whether they were or were not witnesses. Just to bring Your Honour's attention, in previous hearings, certainly in January of this year, the SPO had stated in very clear terms that they were interviewing witnesses. And as Mr. Rees has indicated on a prior occasion, there was an indication that up to 10 witnesses, which we believe witnesses of fact, these witnesses that were being interviewed at that time, were likely to be presented and statements served. I only raise it now because it does cause some concern as to whether statements were taken, whether these witnesses were interviewed, or whether they are now merely relying just on the contact notes. It is an issue of concern as to what has been previously put before the court and what was put before the court last week. I only request clarification as we may need to make a further request for disclosure to the SPO based on the position that's been put forward.
Briefly, Your Honor, in relation to what both defense teams have said, the Gucati defense presents no basis for revisiting the Rule 1023 notice. There's one aspect of the Rule 1023 notice that the trial panel is very well aware of. Disclosure Package 43 does not create any new apparent issue. This was an interview conducted on 25th of August, 2021. Within a week of that interview, a transcript had been prepared, standard redactions had been applied, and it had been disclosed. There was no undue delay. The official note referenced by Your Honor was disclosed under Rule 1023. So when the SPO does have additional Rule 1023 material to disclose, it is disclosing that material, even to this day. In relation to the Haradinaj defense on the interviews with witnesses, if you look on the list of exhibits, there are some interviews with witnesses, transcripts, that are on the list of evidence. They are not submitted at this time. We are waiting for the resolution of the bar table motion to decide whether to retain reliance on those items. But what counsel is saying is not inconsistent with anything that I said last week or the SPO's position in general.
Sorry, anything from the judges? Okay. We can move on to the next topic, which concerns points of agreement between the parties on fact and law, and I note in this regard that the defense indicated in their respective pretrial briefs, and the SPO confirmed in a separate filing, that the Gucati defense agreed to 13 facts and the Haradinaj defense agreed to 3 facts. No agreement as to matters of law have been recorded. Has this changed in any respect, Mr. Rees?
No, it hasn't, Your Honor.
All right. Mr. Cadman?
No, Your Honour.
All right. Anything to add, Mr. Halling? You might want to continue to review that. It seems to me that in all of this material, there might be something else that could be agreed upon that would make our hearing more expeditious without violating anybody's rights. I hope that's an ongoing search and maybe some discussion. All right, connected to this...
Sorry, Your Honor, I can assist in one respect. There is some agreement that became clear from Mr. Halling's oral submissions last week, in that contrary to the pretrial judge's position on, let me just find the right count, contrary to the pretrial judge's interpretation of the offence of retaliation, the SPO appears to agree with the defence position that count 4, that's count of retaliation, is one of specific intent, where an indirect intent or eventual intent is insufficient. The SPO spelt that out a transcript page 490, line 25. So to that extent, there is some additional agreement. But it does seem to us that the elements of the offences will have to be gone through with real care, and there is likely to be real dispute, I'm afraid, in relation to those matters, save for that one aspect on count 4.
We're going to be dealing with that a little later, so
Your Honor.
today. Mr. Halling, is that a correct statement for an agreement?
I don't think so, because the confirmation decision does acknowledge the specific intent in count 4. It's in paragraph 136 of the confirmation decision. So to the extent that the defense is deviating from the approach taken in the confirmation decision, it may not be an agreement. We are forever optimists on this point. If there is a legal discussion today that shows further agreements, we may pursue.
Thank you. Now I give the floor to Judge Barta, who will have some questions in relation to the elements that have just been discussed briefly. Judge Barta.
Thank you, Mr. President. The purpose of my questions today is to obtain some clarifications to better understand your respective positions. If the defense is not prepared to answer these questions today or would prefer to address them later, the panel encourages the defense to consider addressing them at a later stage. Having said that, my first questions are for the prosecution in relation to count 1 of the charges, namely the offense of obstructing official persons in performing official duties by force and or serious threat pursuant to Article 15, paragraph 2 of the law and Article 401, paragraph 1 and paragraph 5 of the Kosovo Criminal Code 2019. My question is, are you, Mr. Prosecutor, arguing that both or only one of the accused personally used force or serious threats, and if so, against whom exactly, and through what specific act or acts?
Thank you, Your Honor. This question I will answer in relation to what is pled in the indictment. The Specialist Prosecutor's Office is alleging serious threats because that is the finding that is made in the confirmation decision. It is made in relation to both accused, and you can see in paragraph 30 of the indictment exactly the itemized list of conduct that is charged for obstructing, sorry, I gave the wrong paragraph. If you look at paragraph 26 of the indictment, you can see the conduct that is itemized there, and you can also see paragraphs 27 and 28 of the indictment for the description of the accused conduct that we are charging that falls under this count.
Mr. Prosecutor, of course, the panel is aware and has read the indictment, and of course appreciate your references to the indictment, but could you please try to specify this a bit more instead of just relying or just presenting the references to the panel? Thank you.
I'm happy to. So, what the SPO is alleging that the accused have done that constitutes obstruction within the meaning of count 1, they've disseminated the confidential information. They have declared that their purpose in disseminating the information was to obstruct the proceedings, and they encouraged members of the public in possession or with access to that information, or certain members of the press, to further disseminate and publish that information. And then in the context of the first and third disclosure specifically, certain further information was indeed disseminated. So in terms of what the actual obstruction is, of course, in terms of what the actual obstruction is, we allege it in 3 parts. Witnesses were intimidated by what the accused did. The SPO's ability to effectively investigate and prosecute those crimes was thereby threatened, and the SPO resources were diverted. To clarify, there were some questions from Judge Gaynor last week where my answer was in relation to what is legally sufficient to prove the obstruction counts in relation to count 2 in particular. And it goes to this discussion of direct and eventual intent. Our case, just to be clear, extends to direct and eventual intent for count 1. And so the conduct is specified here in all of its branches, which apply to both counts 1 and 2. So our case encompasses all of this conduct, but as I was stating last week, there are certain aspects of the elements that have alternatives, and the trial panel need not necessarily reach all findings on all parts in order to enter a conviction.
You can sit down for a moment. Since Mr. Reese brought up the matter of challenging the elements and the motive liabilities in these cases, I'm going to ask the defense, we'll start with Mr. Reese, that if they do challenge the elements of the offenses and the modes of liabilities, could you please tell the panel exactly which elements of the offenses and modes of liability you specifically challenge? As stated.
Yes. The specific order that the trial panel made for the last preparation hearing last week referred to paragraphs 33 to 97 of the decision on the confirmation of the indictment, specifically, and the legal analysis that was set out there in the pre-trial judge's decision. So I've gone through those paragraphs, paragraph by paragraph. And perhaps the best way of answering it, so that you're answering Your Honour's question, so there's some structure, is if I go through those paragraphs. That will obviously take some time if I was to argue the point on each of the paragraphs, but it may help if I just set out the position for them as opposed to argue them.
Yeah, I think that's a good, telling us what I'm looking for that, what your
Yes,
specific challenge is, not necessarily all the argument about it.
Absolutely. So the first section in the pre-trial judge's analysis was violating the secrecy of proceedings. It seems to me that paragraphs 33 and 34 of the pre-trial judge's decision were unobjectionable. They effectively just rehearsed the contents of the charges in Article 39.2 of the Kosovo Criminal Code. Paragraphs 35, 36 and 37 we do not accept. In those paragraphs, the pre-trial judge was effectively interpreting Article 392(1), but without the reference to any authority. He appeared to be making his own interpretation, and that, of course, is not binding on the trial panel. We will submit in due course that his interpretation was too wide, and that the interpretation of offence in accordance with the Kosovo Criminal Code should always be interpreted narrowly, as opposed to taking a wider interpretation.
We'd like to interrupt you for just a moment. Judge Matruh had a question or a comment.
Apologies to interrupt you, Mr. Rees.
Not at all, Your Honour.
Apologies to interrupt you, Mr. Rees. The record of the transcript, page 13, line 13, suggests that you said in reference to paragraph 33 and 34 that these paragraphs were an objection. I heard you to say they were unobjectionable. Could you clarify this?
Unobjectionable. Yes. And they, as I say, they essentially just appear to rehearse the article itself, the Article 3921. So paragraphs 35, 36 and 37 we do not accept. And using the shorthand, it's interpretation by the pre-trial judge without any authority, and we say that in those circumstances the trial panel will have to make its own resolution on those matters. Paragraphs 39 to 40, we will submit that for both forms of intent, a perpetrator under Article 3921 must have knowledge that the information was secret. And we draw authority for that proposition from the Kosovan case in the Court of Appeal in Kosovo, MZ reference PAKR 336/16, judgment of the 13th of December 2016. We note as well that within the analysis of Article 3921, the pretrial judge says nothing there about authorization. And it is, of course, an essential element of the offence that any revelation of information is without authorization. We say the prosecution will have to prove absence of authorization, and we will submit in due course that authorization in that context should include disclosure where disclosure is in the public interest. We say that the public interest element is part and parcel of Article 3921 when looking at the issue of authorization or not. The pretrial judge then went on to look at the other aspect of Article 392 for these purposes. Article 392.2 and 392.3, the unauthorized revelation of the identity of or personal data of protected persons, and the aggravated offence where there are serious consequences for the person under protection, or the criminal proceedings are made impossible or severely hindered. Again, paragraphs 41 and 42 of the pretrial judge's decision appear unobjectionable in the sense that they rehearse the content of those articles. Paragraphs 43 to 46 we do not accept. Again, its interpretation by the pretrial judge without authority. Paragraph 50 we specifically do not accept. In that paragraph, the pretrial judge suggested that the perpetrator must have known or had reason to know, he put forward as an alternative, that he or she was revealing the identity or personal data of protected persons. Again, we will submit that for the purposes of Article 3922 and 3, as well as for 1, sub-Article 1, the perpetrator must have known that in this case the identity or personal data was protected. And again, we draw that proposition from the same authority, the Kosovan Court of Appeal case of MZ, reference previously given at page 7 of that decision. The panel noted that in order to violate the identity of a protected witness, the perpetrator should have known about the existence of the order and its content. The order and its content being in that case the order protecting identity or personal data, and indeed the content of the order, the extent to which it was protected. In the absence of that knowledge, the perpetrator could not be found guilty. The pretrial judge then turned to retaliation, the offence of retaliation. Whoever takes any action harmful to any person, including interference with lawful employment or livelihood of any person, with the intent to retaliate for providing truthful information relating to the commission or possible commission of any criminal offences to police, an authorised investigator, prosecutor or a judge shall be fined and punished. Again, paragraph 51 simply rehearses the content of Article 3881. In relation to paragraph 52, the pretrial judge missed the important element that needs to be proved. That is, that the perpetrator acts with the intent to retaliate for providing truthful information. Paragraph 53 is not accepted. Again, its interpretation by the pretrial judge without any authority and support. We do not accept, for example, that harm should be interpreted in the case of Article 3881 to extend to including interference with well-being, privacy or dignity, as the pretrial judge suggested, again without authority. The content of paragraph 54 is not accepted. The pretrial judge again missed the important element, not only that the perpetrator must act with the intent to retaliate for providing truthful information, but the pretrial judge missed the important element that the information provided must be truthful. That is an element of the offence that the prosecution must prove. Paragraphs 55 and 57 are not accepted again. in those paragraphs, despite acknowledging that there was a specific intent, the pretrial judge nevertheless went on to say that a direct intent and an eventual intent would suffice. We say that an eventual intent will not suffice for the offence under Article 3881. As the intent to retaliate for providing truthful information is explicit, it's an offence of specific intent, and we will submit that only a direct intent in those circumstances will suffice for Article 3881. We had thought that the SPO had agreed with the defence. We had thought that the SPO agreed with that proposition in light of the submissions made by Mr. Halling, again at transcript page 490, line 25. But perhaps it looks like we had misunderstood the SPO's position. Perhaps they can clarify that. The pretrial judge then turned to intimidation. Under Article 387 of the Kosovan Criminal Code, which provides whoever uses force or serious threat or any other means of compulsion, a promise of a gift or any other form of benefit to induce another person to refrain from making a statement or to make a false statement or to otherwise fail to state true information to the police, a prosecutor or a judge, when such information relates to obstruction of criminal proceedings, shall be punished. Paragraph 58 of the pretrial judge's analysis is not accepted. Article 387 requires force or serious threat or any other means of compulsion or promise of a gift or any other form of benefit. For these purposes, I'll continue to use requires force or serious threat, etc., as it were. The article requires force or serious threat, etc., to induce another person to refrain from making a statement. That is, it requires, we say, that a person is induced to refrain from making a statement or otherwise failing to state true information, so on. But again, for shorthand purposes, I'm going to concentrate on making a statement. So we say that this is an offence which requires proof of consequence, that a person was induced to refrain from making a statement. We do not accept the proposition from the pretrial judge without authority that the force or serious threat, etc., can be directed at a person making or likely to make a statement. We do not accept that that's sufficient. Article 387 also requires that the information which was to be provided and wasn't as a result of the force or serious threat, it requires that that information relates to the obstruction of criminal proceedings. That is an element that the pretrial judge has missed entirely in his analysis. Paragraph 59 is not accepted. Article 387 does not prohibit, as the pretrial judge said, any conduct that may have or is expected by the perpetrator to have an impact or influence on the statement or information to be given by the person. We will submit that Article 387 only prohibits the use of force or serious threat or any other means of compulsion, a promise of a gift or any other form of benefit, and, as I've already raised, that it requires another person to be induced to refrain from making a statement or to otherwise fail to state true information. The judge's analysis in paragraph 60 is not accepted. And I do add the caveat that I acknowledge that the definition in Article 113 of the Kosovan Code of force, the word force, the term force, appears to be comprehensive in that it defines force for the purposes of the code. So Article 113, the definitions article, begins, for the purpose of this code, the terms below have the following meanings. And force, at sub-article 15, is given the meaning, the implementation of hypnosis or other means of intoxication for the purpose of bringing a person against his or her will into a state of unconsciousness or incapacitating him or her for resistance. That's a definition given in Article 113. If force, for the purposes of Article 387, and despite what is said in the definition section, is said to include the use of some other form of physical violence, we nevertheless draw attention to the definition requiring the person being brought into a state of unconsciousness or incapacitation. We will submit, therefore, that the offence in Article 387 should be interpreted both in the use of force and in the use of serious threat to relate to the actual or threatened use of serious force, which has the consequences set out in Article 135.
Watch your speed again, Mr. Rees. You kind of accelerate once in a while. It makes it difficult. And also, can you give us an estimate of how much more you have on this subject?
The same length again.
Okay.
You did ask, Your Honor.
Go ahead.
And I do my best to help.
Yeah, go ahead.
The fact is, we do not accept the analysis that the pre-trial judge set out. We say there are a number of aspects in relation to each of the offences.
Understood, and I'm not limiting you. I just want you to don't go into the argument as much. Point out the positions that you're going to take.
Yeah. Paragraph 61, we do not understand what the pre-trial judge meant by a potential witness in the circumstances of an offence under Article 387. Paragraph 62 is not accepted. As I've already said, we will submit that the offence requires proof that the aforementioned acts do have a particular effect on the person, namely that they induce another to refrain from making a statement. The pre-trial judge made a comparison then between Article 386 and 387, which is a useful exercise, but the pre-trial judge, we will submit, got that analysis wrong. The pre-trial judge did accept that Article 386 requires proof of consequence. He spells that out in footnote 42. Like Article 387, the Article 386 offence can be committed by bribery, making a promise or offering a benefit, the threat, violence, or other form of compulsion. There is a considerable overlap between the offence under Article 386 and 387. Article 386 requiring proof of consequence, we say Article 387 does also. We note, and the pre-trial judge did not comment on this, that the maximum penalties, both prescribed punishments and maximum punishments, for Article 387 are more severe than Article 386, which would make little sense if Article 386 required proof of consequence, but Article 387 did not. We say the aggravating feature and the distinction between the two offences of Article 386 and Article 387 offences is that the Article 387 offence must occur in relation to proceedings for an Article 386 offence. It's aggravating because it demonstrates persistence to obstruct not only the original proceedings, the Article 386 offence, but proceedings for obstructing the original proceedings, and we say that's the Article 387 offence. Paragraph 63 to 65 on intent are also not accepted. We say the offence is an offence of specific intent. That is, the purpose or desire, the direct intent required, is to induce a person to refrain from making a statement. We say that the perpetrator can only have a direct intent for the purposes of the offence. In relation to obstructing official persons in performing official duties, Paragraph 67 and 68 are not accepted, and that's because they relate, the pretrial judge referred the reader back to his analysis of force and threats and other means in relation to earlier passages of his analysis. We say that serious threat in this context means serious threat of force. We will also submit that Article 4011 does require the force or serious threat to be directed against the official person. The pretrial judge, in setting out a contrary position, had no authority for the proposition that it does not. And he noted that the wording in 401 does not refer to using force or serious threat against the official person, but in fact, the article does. In Article 4015, the aggravated offence, the words specifically refer to when the offence is committed against a judge and the other official roles, but for shorthand purposes, against a judge during the exercise of their official functions. We say that makes it clear, if it was not already clear, frankly, from the face of Article 4011, that the force or serious threat needs to be directed against the official person. Paragraph 69 and 70 are examples, again, of the judge making interpretation of the article without authority. In relation to paragraph 73, that's not accepted. We say that the prohibited consequence for the purposes of Article 401, 1 and 5 is the obstruction or attempted obstruction of an official person by the use of force or serious threat. It is not enough for eventual intent that the defendant is aware that an official person might be obstructed. We will submit the defendant must use force or serious threat against an official person, must be aware that the obstruction of an official person in performing his official duties by that force or serious threat can occur, and that he accedes to that occurrence.
I'm going to ask you to wrap it up in 5 minutes.
Your Honor. The obstruction of an official person itself is not prohibited. It can, of course, occur through lawful means. And we also add that when the offence is one of an attempt, which is alleged on the indictment, that only a direct intent will suffice for an attempt. The judge then moved to obstruction of official persons by participation in a group. We do not accept paragraph 75. We will submit that common action, as referred to in Article 401, must refer to common action to use force or serious threat. Otherwise, on the pretrial judge's analysis, otherwise perfectly lawful joint activity, such as class litigation, would be penalised, and we will submit that that cannot be right. We do not accept paragraph 76 for the same reasons as we will make submissions in relation to Article 4011. And in relation to paragraphs 78 and 80, they are not accepted. The intention required, we will say, is a direct intention, namely the desired use of force or serious threat by 3 or more persons. The use of the word common makes it clear that only a shared direct intention by 3 or more persons will suffice. In relation to modes of liability, therefore, to the extent that I haven't dealt with anything thus far, we do not accept paragraph 82, where the pretrial judge submitted that an eventual intent was sufficient for all charges. In relation to paragraphs 84 to 87, they're not accepted either. We will say that co-perpetration, a form of perpetration where several persons, each of them fulfilling required elements for a perpetrator, knowingly and willfully commit certain criminal acts, that requires specific intent. It's there in the pretrial judge's definition of co-perpetration, that is, knowledge and willfulness is required. We will also submit that the actions of the co-perpetrators must be concerted in the course of perpetration of the offence.
Some of these same points are going to be covered by Judge Barta, so you'll get another shot at it anyway. So.
Yeah.
All right, Mr. Cadman, anything further?
Your Honour, nothing really further from me that I need to add. I have I would say, the rather luxury of having to follow Mr. Rees on his points.
Well, and
We have,
as I said, Judge Barta is going to be asking some questions, so you'll have a chance. Anything you want to respond? Bear in mind that Judge Barta is going to be running through some of this same information.
Understood. Very briefly, just to say, we had no notice of the defense presenting the full exposition that they just gave. We would like an opportunity to respond to it in writing. It's impossible on the fly to respond point by point in the moment. So my suggestion would be for the court, whatever questions the judges have, we're prepared to answer today and to state our position. And if the judges would like further submissions responding to what the Gucati defense has just said, we'd like an opportunity in writing to do that.
Let's see how this goes with Judge Barta's questions, because they're quite extensive and cover the territory as well. So I'll just give the floor to Judge Barta, and he can continue.
Thank you, Mr. President. We are still dealing with the charge, count one, namely the offense of obstructing official persons and performing official duties. My question again to you, Mr. Prosecutor, are you saying that both accused used explicit threats or just implicit threats? Could you please clarify this for the panel?
We're saying that the threats that they made constitute serious threats within the meaning of the provision. It includes the conduct that they said. The conduct that they said sometimes is explicitly threatening, and sometimes it is implicit in their statements. So we're actually charging both, but both meet the code provision.
Thank you. Maybe, Mr. Prosecutor, again, for the purpose of clarification, the panel notes that in paragraph 97 of your pretrial brief, it is stated that the accused actions, and I quote, were carried out directly by serious threats directed at the SPO and indirectly by serious threats to witnesses and others against SPO officials, including prosecutors, investigators, and other staff members during an exercise of their official functions, specifically the SPO's ongoing criminal investigations, unquote. Mr. Prosecutor, there's no need, of course, to reveal names of members of the SPO to answer this question, but please could you explain whether you allege that specific members of the SPO were specifically threatened by one or both accused, and if so, which acts of the accused amount to serious threats specifically against SPO staff? Thank you.
The serious threats alleged are directed towards witnesses within the meaning of the provision. The effect of that had an effect on the SPO's office. There is no one particular official within the office that was obstructed differently than the others, but the effect of the accused conduct obstructed official persons in the course of their duties. So this is why the indictment, for instance, doesn't charge any particular named official, but does charge that the accused conduct obstructed the official person.
Thank you, Mr. Prosecutor, that helped. My next question is also for the prosecution, and it concerns, again, the offense of obstructing official persons and performing official duties. Could you please explain how, and this is a follow-up question, actually, to what you just said, how the work of the specialist chambers and or SPO officials was affected and or delayed as a result of the actions of the accused or the alleged actions of the accused, in particular, what official duties were performed or not performed. Of course, Mr. Helling, the panel is aware that you indicated that one of your witnesses will testify in this regard, but maybe it's possible just to sum up or to summarize your position on this. Thank you.
Thank you, Your Honor. And the court is correct that W04842's testimony does go to this point amongst others. The way in which it obstructed was because witnesses were intimidated, the SPO's ability to effectively investigate crimes was thereby threatened from that intimidation, and that resources were diverted to address the actual and potential consequences to the witnesses and also to KSC proceedings as a whole. So this is a summary of the conduct that we are describing as being obstructing within the meaning of counts 1 and 2.
Thank you, Mr. Prosecutor. My next, actually 3 questions are for the defense, and I apologize in advance to Mr. Rees that maybe I missed some of the points you mentioned, and maybe you will have to repeat yourself in this regard. So my first question to both, of course, defense counsel is, starting with Mr. Rees, did I understand you correctly that you don't agree with the pretrial judge's finding in paragraph 68 of the confirmation decision that the crime or the offense of obstruction, Article 401, paragraph 1 of the Kosovo Criminal Code, does not require that the force or serious threat is directed against the official person, and that rather the force or serious threat may be directed against one or more other persons as long, and I quote the pretrial, I cite the pretrial judge here, as long as it results in the obstruction or attempted obstruction of an official person in performing official duties. Of course, Mr. Rees, if you touch upon this, I believe, but you don't, or as a matter of fact, you don't have to repeat yourself, or you don't have to repeat all the arguments, but just to clarify, could you clarify this?
Yes, we do not accept that. We will submit that Article 4011 does require the force or serious threat to be directed against the official person. As I say, the judge's interpretation is an interpretation that he had no authority for, and he did not observe that Article 4015 in particular states that the offence is to be committed against a judge, an other official person, judge, etc., during the exercise of their official functions. So we say that the threat or serious force, the force or serious threat must be directed against the official person.
Thank you, Mr. Cadman.
Your Honour, our position is exactly the same, and to all of these points we will be submitting upon direction in the fullness of time. Justification for all of the challenges that Mr. Rees has set out.
Thank you, Mr. Cadman. My next question also for the defense. I think, Mr. Rees, at least I cannot remember that you touched upon this question, so maybe it's a new question, I hope. Does the prosecution, this is my question, have to prove that the actions of the accused were directed against the performance of specific official duties, for example, against a specific investigative measure, such as the execution of a search warrant or the seizure of evidence? Mr. Rees, you have the floor.
Can I reflect upon that point? Thank you.
Mr. Cadman?
I imagine we will be jointly reflecting on that point, and one or either of us will respond to that at a later time.
Thank you. Of course, the prosecution is already. Do you want to comment, or do you have a position on this, Mr. Prosecutor?
We do, Your Honor. It's similar to the answers to the previous question. It doesn't have to be proven that specific investigative measures were affected in order to prove count 1.
Thank you, Mr. Prosecutor. My last question also, especially to the defense, is last question on count 1, actually. Are there any other legal requirements not expressly foreseen in Article 400, paragraph 1 of the Kosovo Criminal Code, such as the requirement of simultaneity, meaning that the force or threat has to be simultaneous with the official act which the official person undertakes within his or her powers? And I refer to a commentary on the Kosovo Criminal Code 2012, published by Salihu, Sitia, and Azani, in 2014, more specifically to Article 409, paragraph 1, margin number 4. Because I don't expect both parties to have a specific view on this, but if you want to take the floor, this is your chance, Mr. Rees.
Your Honour, I'm grateful for Your Honour raising the matter. Again, we'd like to reflect on that point as well, please. Thank you.
Certainly, I think we'd like to consider the commentary and then certainly come back.
Mr. Prosecutor.
I guess we'll take the same opportunity. The answer to Your Honor's question depends on what that word simultaneity means. And so after consulting the commentary, we can give a more considered response.
Thank you, Mr. Prosecutor. I'm now moving to Articles 401, 2, 3, and 5 of the Code of Criminal Code 2019. This is count 2 of the indictment, the offense of obstructing official persons and performing official duties by participating in the common action of a group in relation to which I have a question for the prosecution. I note that the case law, or that case law on this offense relates primarily to instances of mob violence in which the persons committing the obstruction could not be identified, or, in the words of the Kosovo Court of Appeals in the case of M.I. et al. Of 28th May 2014, this is case number PAKR 513/2013, it was not possible to establish the specific individual actions of obstruction. In that context, I would like to ask you what the relationship is between paragraphs 1 and 2 of Article 401 of the Kosovo Criminal Code, and more specifically, is your position that both paragraphs are jointly applicable in the present case, Mr. Prosecutor?
The answer to the last question is easiest because it's yes. The way that we've charged the case, both of them are charged at the same time. We are mindful of Kosovo cases addressing count 2 in the context of mob violence. It is our position that that is not the only context to which these elements apply, and that if you do have a situation where obstruction occurs through participation in a group of persons doing this by common action, such as the way pled in the indictment, that that also meets the elements of this offense.
Thank you, Mr. Prosecutor. Mr. Rees and Mr. Kapman, would you like to comment on this?
Yes, Your Honour. As I set out earlier, we submit the relationship between Article 4011 and 4012 requires the common action to refer to common action to use force or serious threat. We say that the much wider interpretation applied by the pretrial judge cannot be right, because on the pretrial judge's analysis, otherwise perfectly lawful joint activity, as I gave the example earlier, of class litigation would be penalised, and that cannot be right. We say that common action in Article 4012 refers to common action to use force or serious threat, and we say that the use of the word common makes clear that the group can only act in a common action where they share the specific direct intention shared by 3 or more persons. That's the submissions that we will make in relation to Article 4012 and 3.
Thank you, Mr. Rees. Mr. Kapman.
Nothing further to add, Your Honour.
Thank you. Counsel, let us now go to Article 387 of the Kosovo Criminal Code. This is count 3, the crime of intimidation. I think we already touched upon this, whether this crime is a specific intent crime as well or not. The panel is in this regard interested in both parties' positions on the reasons for the respective positions, whether it is or whether it is not a specific intent crime. I would like to start with the prosecution. Mr. Helling.
Thank you, Your Honor. Our position is that there is no specific intent within this provision. And the reason why is just an exercise of statutory construction. If you compare it to count 4, which is where the specific intent was identified by the pretrial judge, that provision indicates whoever takes any action harmful to any person, including interference with lawful employment or livelihood of any person, with the intent to retaliate for providing truthful information. There is no equivalent language in Article 387. And so in our assessment, the pretrial judge was correct in setting out the objective and subjective elements without reference to a specific intent here.
Thank you, Mr. Prosecutor. Mr. Rees.
We say that the wording in Article 387 makes it clear that it is an offence of specific intent. The use of force or serious threat must be to induce. The purpose of it is to induce. That imports a specific intent, a direct intent only.
Thank you, Mr. Rees. Mr. Kedman, nothing further. Sorry, excuse me. My question on this count, or my next question actually on this count is, again, to the defense. Maybe I missed that, Mr. Rees. Could you please repeat whether you agree or not agree with the pretrial judge's finding in paragraph 62 of the confirmation decision that for Article 387, the SPO will not have to prove that the acts of the accused had any particular effect on potential witnesses? Thank you.
We will submit that Article 387 does require proof that the aforementioned acts have a particular effect on the person, namely that another person was induced to refrain from making a statement relating to an offence under Article 386. The pretrial judge's analysis, again without any specific authority, but his analysis drew on a comparison with Article 386, which he did accept in in footnote 40. Sorry, in footnote 40, he did set out that Article 386 does require proof of consequence. He didn't look at Article 386 in any greater detail, and we submit that if one does carry out a proper analysis of the two offences, it does support our position that proof of consequence is required for 387 also. Article 386, the offence can be committed, like Article 387, by use of force, serious threat, forms of compulsion, promise of a gift, or any other form of benefit. It covers the same conduct in that regard, the two offences. We note, the pretrial judge didn't, but we note that the prescribed and maximum punishments for Article 387 are more severe than under Article 386, which we submit would make little sense if, as on the pretrial judge's analysis, Article 386 required proof of consequence, but Article 387 did not. So we say that the elements of the offence are to a large degree overlapping. The aggravating feature, though, of Article 387, the element that makes it a separate offence, missed by the pretrial judge, is that proceedings for an Article 387 offence must relate to inducing another person to refrain from making a statement relating to the obstruction of criminal proceedings. So, the words of Article 387 of the Kosovo Criminal Code set out whoever uses force or serious threat or any other means of compulsion, promise of a gift, or any other form of benefit to induce another person to refrain from making a statement, or to make a false statement, or to otherwise fail to state true information to the police, a prosecutor, or a judge, when such information relates to obstruction of criminal proceedings shall be punished. Obstruction of criminal proceedings is the offence under Article 386. The Article 387 aggravated offence is when an offender demonstrates persistence to obstruct not only the original proceedings, that's an Article 386 offence, but proceedings for obstructing other proceedings. That is the Article 387 offence. Both require proof of consequence. Article 387 requires proof of consequence that a person was induced not to make a statement in proceedings for an Article 386 offence.
Thank you, Mr. Rees. Mr. Kettman, anything further, or the SPO? First, Mr. Kettman, sorry.
Your Honour, nothing further, only just to say that this is a point that Mr. Rees and I have considered at some length, and the proof of consequence has to naturally flow from that. As Mr. Rees has quite properly set out, the sentencing for the two provisions means that it has to be interpreted in that way.
Thank you, Mr. Kettman. Mr. Elling.
It does not have to be interpreted that way. The difference between the sentencing ranges in the two provisions can also be explained by the fact that Article 387 talks about conduct including force or serious threats, including by means of compulsion, whereas Article 386 doesn't have that same kind of aggravating conduct. The defense's reading requires the trial panel to ignore a contextual reading of this part of the Kosovo Criminal Code. The fact that Article 386 talks about causing a particular result, and Article 387 does not talk about causing the same result, is indeed meaningful. Were Article 387 to include consequences within it, then it would be redundant with Article 386. So the distinction between the two provisions is in the nature of the conduct being sufficient, whereas it's sufficient for 387 and not for 386, but the conduct itself has more gravity in Article 387. And that is the only reconcilable reading between these two provisions, and by the way, it matches the way that the sentencing schemes are set out for each.
Thank you, Mr. Prosecutor. I'm now moving to questions relating to count 4, the offense of retaliation. My only, I have to say, remaining question on this count is to the defense, and it serves the purpose of clarification. Mr. Rees, I think you already touched upon this. Am I correct that your position is that the SPO has to prove that the person concerned provided truthful information? My question is here, I think you already said this, are you saying that the truthfulness of the information is part of the actus reus and or mens rea of the offense of Article, or in Article 388 of the Kosovo Criminal Code?
Both.
I thought so. Thank you. Mr. Kettman, anything further? Mr. Prosecutor.
Yes, on this we did want to make a submission that the way that the code provision is written, it's actually a subjective element. We are mindful that the confirmation decision discussed this in the context of the objective elements of the offense. However, the code provision clearly says that it acts with the intent to retaliate for providing truthful information relating to the commission or possible commission of any criminal offense. The pretrial judge did correctly state the element, though, and if you look later in the confirmation decision, that is applied to the facts in a way where no assessment of the truthfulness or not of the information was done. And in our assessment, that assessment is correct in interpreting Article 388 of the Kosovo Criminal Code. This is in relation to the object of the harmful action, and therefore it is a mens rea element. Thank you.
Thank you, Mr. Prosecutor, for the clarification. My next question for the defense is in relation to count 5, violating the secrecy of proceedings through unauthorized revelation of secret information, Article 392, paragraph 1 of the Kosovo Criminal Code. And I also apologize, Mr. Rees, maybe I missed that, but also in order to clarify, or for the purpose of clarification, am I correct that you don't agree that protected information within the meaning of Article 392, paragraph 1 includes, and I quote, any material pertaining to SPO investigations, including cooperation with other entities, as well as any documents marked or referred to as confidential or internal, unquote, as the pretrial judge stated in paragraph 37 of the confirmation decision? The floor is yours.
I don't accept that. The wording of Article 392(1) is specific. It refers to information disclosed in any official proceedings which must not be revealed according to law or has been declared to be secret by a decision of the court or a competent authority. The scope of those words, as I understand the pretrial judge's decision, was a matter for his own interpretation. He applied a wide interpretation, and he did so without any authority to draw upon. We will say in those circumstances that the trial panel has to look afresh at those words. We will invite them to be interpreted narrowly, because that's consistent with the approach that is required in the Kosovo criminal procedure, in the Kosovo criminal code. And the trial panel will have to define the scope of those words itself.
Thank you, Mr. Rees. Mr. Kempman, anything further? Mr. Prosecutor.
Just briefly, Your Honor, I could read the same element back and emphasize the according to the law part, which in and of itself is sufficient to meet the elements. The pretrial judge gave a detailed exposition about what law applies in the paragraph cited by Your Honor, and that's our position that that's correct on all counts.
Thank you, Mr. Prosecutor. Moving on to a question to all parties in relation to count 6, which is violating the secrecy of proceedings through unauthorized revelation of the identities and personal data of protective witnesses. The question is as follows: does Article 392, paragraph 2 of the Kosovo Criminal Code, which provides in relevant part that whoever without authorization reveals information on the identity or personal data of a person under protection in the criminal proceedings or in a special program of protection shall be punished by imprisonment of up to 3 years, also protect persons whose identity and or personal data appear in material provided to the SPO by third parties? And I refer to paragraph 44 of the pretrial judge's confirmation decision. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Our answer to your question is yes. Paragraph 44 sets out the requirements in the confirmation decision. And when we talk about protected witnesses in count 6, that needs to be read with the definition of witnesses provided in the indictment, which, as discussed in our filing on a previous occasion, goes beyond merely persons being called by the Specialist Prosecutor's Office. So all people falling within this paragraph and falling within the definition of a witness, as explained by the SPO, fall under the count.
Thank you, Mr. Prosecutor. Mr. Rees, anything? Any comments?
Again, Your Honor, I make the general, set out the general position that we will, in effect, require the trial panel to look at this afresh. The pretrial judge makes an interpretation, wide interpretation of the meaning of those words without authority. We will, in due course, invite the trial panel to look at those words again. The scope of them will have to be determined within this context by the trial panel. We will urge a narrow approach to be taken in accordance with the Kosovo Criminal Procedure Code. There are other aspects of the analysis in relation to the unauthorized revelation of the identity or personal data of protected persons that we also take issue with. As I've said earlier, we will submit the perpetrator must know that the identity or personal data was protected, referring to the Kosovo Court of Appeal case of MZ, where they said the perpetrator should have knowledge about the existence of the order that protected the witness and its content. And we also note that there is no analysis within the pretrial judge's decision about authorization and the absence of it for the purposes of this offence, which is, of course, a necessary part of the offence.
Mr. Kelman, anything further from your side?
Just to emphasise and endorse the position that, as we've stated, the pretrial judge had taken a very broad interpretation. The trial panel is going to have to, we are going to invite the trial panel to consider these matters afresh. And again, in the fullness of time, we will be submitting our full position on this.
Understood. Thank you all.
You're right.
Yeah.
Before we leave that offence, there is actually one other matter, one other issue that I should raise. The words of Article 3923, the aggravated offence, refer to criminal proceedings being made impossible or severely hindered. We take issue with what we would say is a watering down of that high hurdle that occurs in the analysis carried out by the pretrial judge in relation to the issue of consequences and the extent. So raise that as well.
Thank you, Mr. Rees. These were my questions in relation to the elements of the crimes. Unless my colleagues have other questions on this topic, I will move on to questions pertaining to the modes of liability. Thank you, Mr. President. My first question in relation to the modes of liability is a generic question, and it's for all parties, namely, what is the relationship between the different modes of liability contained in the indictment, in particular, the relationship between co-perpetration and incitement? I will give the floor to you first, Mr. Prosecutor.
The relationship between the modes of liability charged is set out most clearly in the statement of crimes at paragraph 47 in the indictment. They are alternative modes of liability specified in relation to the counts as enumerated in that paragraph. As concerns co-perpetration and incitement specifically, and as found in the confirmation decision, the elements of those two modes of liability are different. In particular, it is noted that incitement actually has variations in the Kosovo Criminal Code that do not appear in relation to joint perpetration. So there are distinctions made by the pretrial judge that in our submission explain why these are alternatives that are set out separately in the indictment.
Mr. Rees.
Well, the indictment, of course, is a matter for the prosecution. We have also wondered what the relationship is between the modes of liability alleged. The only conclusion we could form was that the prosecution throw all alternatives at Mr. Gucati and Mr. Haradinaj. We will reflect further, but for my part, there was little further assistance in understanding the prosecution's case from the observations just made by the SPO.
Thank you, Mr. Rees. Mr. Kedman, nothing further. Thank you all. My next question, or next questions actually, are for the SPO, for the prosecution. Again, in relation to incitement pursuant to, in this case, Article 32, paragraph 2 of the Kosovo Criminal Code. My question is, which specific offenses were only attempted but not committed, be it by the accused or by members of the media and or other persons? Mr. Prosecutor, you have the floor.
Thank you, Your Honor. As I was specifying, these are stated as alternative modes of liability. So in terms of what is charged in relation to Article 32.2, it would be all of the counts as specified in Article 47, subparagraph 5 of the indictment, which is inciting the commissions of crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings. The conduct alleged is the same. It depends on how the trial panel finds the facts in this case. Certain alternatives may become activated and other alternatives may become unavailable. We have set the scope of the accused liability in the indictment, and that has been confirmed and has withstood a preliminary motion arguing defects in the indictment. So that is our position on this. Incidentally, when I speak of alternative modes of liability, that is a different question as to whether convictions can be entered on inchoate offenses, some of which are listed as modes of liability here. This is a submission that we were intending to make in writing at a later time.
Thank you, Mr. Prosecutor. Anything from the defense? Mr. Kedman? No. Thank you. Our next question is also for the prosecution. Mr. Prosecutor, I note that Article 32, again incitement, 32 paragraph 3 of the Kosovo Criminal Code states that, I quote, whoever intentionally incites another person to commit a criminal offense punishable by imprisonment of at least 5 years shall be punished for attempt. Given that none of the crimes with which the accused are charged has a minimum sentence of 5 years imprisonment, Mr. Prosecutor, do you consider that this article, namely Article 30, I repeat again, 32 paragraph 3, might not be applicable in the present case? The floor is yours, Mr. Prosecutor.
Our position is that the sentencing range in Article 32.3 is indexed to the sentencing range for the other offenses. So if one of the crimes charged has a sentencing range that can exceed 5 years, even if not the minimum sentence, if it can cross 5 years, then it is eligible under this provision. And this is not just our understanding, but it's also the understanding of the pretrial judge, which confirmed this mode of liability on that understanding.
Just a follow-up question. If you look at, Mr. Prosecutor, Article 28, paragraph 2 of the Kosovo Criminal Code, there the wording is used, a punishment may be imposed. So my question is, do you see a difference between these two provisions, Article 32, paragraph 3, and Article 28, paragraph 2, in relation to the wording?
I don't know if I'm answering Your Honor's question, but there is a difference in the way in which the offenses charged fall within each of these provisions. Because one of the offenses charged exceeds 3 years, but is less than 5, you can see that the indictment charges it differentially because of this point. So it's not our position that these provisions are giving an interpretation that clash with each other in relation to what I just told you, but because they set out different sentences that need to be hit by the sentencing ranges charged, that does affect when we are charging attempt and when we are charging Article 32.3 incitement.
Thank you, Mr. Prosecutor. Anything further?
It's a very good point, Your Honour. I'm happy to adopt it.
Likewise, Your Honour.
Thank you, counsel. Those were my questions. Thank you, Mr. President.
Any other questions from the panel? I'm sorry. We would acknowledge receipt of the defense submissions on the definition of public interest, legal basis relied upon for entrapment, jurisprudence, and legislation. The panel is grateful for your submissions on these topics, and we will take them into consideration. We will take a break until 11:30 in just a moment. I just want to thank everybody for their candor and preparation in addressing these complicated issues. And it was very instructive and I think helpful to us and helpful to all of you as well. So we will be in adjournment until 11:30.
All rise. All rise.
Move on to the next topic, which is the number of SPO witnesses. I note in this regard that the SPO has submitted on September 6th a request to add one witness to its list and a number of connected exhibits to its exhibit list. I'm going to give the floor to Judge Mitro, but before I do that, I have a note that I want to share, or I want to at least tell you about. The panel has observed that some of the SPO filings contain substantive submissions in the footnotes, and we remind all parties that any substantive matter be addressed in the body of the filing rather than in the footnotes, so that the risk of missing out on any relevant part of the submissions is reduced. It'll help us greatly. Now I give the floor to Judge Mitro.
Thank you, Judge Smith. We will give the floor first to the defense, which was ordered to respond during the conference last week to the SPO's request to add a witness to its current list, and we wanted to give you the opportunity to address the matter orally now. So Mr. Rees, and then I will come to Mr. Cadman in a second.
Thank you. My request at this stage is for some further assistance from the Specialist Prosecutor as to the nature of this witness's evidence. And I preface that by referring back, as Judge Barter did this morning, to that part of the indictment that alleges the commission of crimes by others, and at the incitement, it is alleged, of Mr. Gucati and his co-accused. So paragraph 47, 4, paragraph 47.4 of the indictment, as Mr. Hallin referred to this morning, specifically alleges that the accused incited and insisted in the commission of the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation and violating the secrecy of proceedings. Witness 04866. That witness.
One moment. Do we need to correct the transcript to remove the name? All right, go ahead, Mr. Rees.
Well, do we need to go into private session now then? Because clearly I need to refer to material that's in the document, in the disclosures. I mean, there's been...
Just, the only thing you're wanting protected is the name?
That's correct, Your Honor.
Do you need, so you can, and the
I'm
pseudonym is...
Can I just say in passing that we were conscious that, firstly, that there was no application for protective measures in relation to this witness. And indeed, the document that was disclosed to us and is referred to in the SPO's note, where they file requesting permission to add this witness to the exhibit, in the note referred to, the witness makes it perfectly clear he's got no issue with his name being referred to in public. But be that as it may,
just
the
hold on,
witness...
Mr. Rees. I think the prosecutor wanted to respond.
Just in relation to that, Mr. Rees is correct that we are not seeking protective measures of this witness if he is added to the witness list. our position that it draws unnecessary attention to him up and until that request is granted. So for the moment, we filed it confidentially for this reason, and just that his name and anything that would identify him just be not discussed in open session, but everything else can be said without defeating the purpose of the classification.
We'll proceed using the pseudonym.
Thank you, Your Honour. So the witness produces articles that he is responsible for. They are open source articles. They're publicly available on the internet, as I understand it. During the course of those articles, he refers to, inter alia, the cooperation between the investigative task force and Serbian authorities to collect evidence regarding alleged crimes committed during the war, which are now being investigated by the special court. Documents show very clearly how the task force cooperated with the Serbian authorities. They contain correspondence between them and exchange of letters. The system used here is mostly through requests to collect evidence given by former police officers and chiefs of police stations with the instruction to locate witnesses and to gather as much evidence as possible.
Slow down, Mr. Rees.
About the cases and alleged crimes. The files contain numerous names of witnesses, most of them Serbs, but there are also Albanian, Roma, Ashkali names as well, reports In Focus. In Focus will not publish any of those names. However, this article will show the mode of cooperation between the task force and Serbian authorities. How did the cooperation between the task force and Serbian authorities work? We learned from the correspondence of these letters that a key role was played by virtually the Serbian entire state structures.
Mr. Rees, right now the application that's before us is exclusively an application for leave to add a witness and a number of associated exhibits to the SPO's list. So can we ask you to focus on that particular matter and to leave aside any issue of substance or merit, as the case might be or not, of the material for a later stage? Would be grateful.
To their witness list. I was referring to the article because your honours will have already noted that there is material there that I've already read that is complained about in the indictment and in the prosecution pretrial brief. As particulars that in relation to Mr. Gucati and Mr. Haradinaj, the SPO make complaint about. The article continues by naming Vladimir Vukcevic, former chief war crimes prosecutor, but also Milovan Drecin. Again, names that were mentioned in the first press conference to some criticism from the SPO, and it forms part of the SPO's case against these accused. Does the SPO, and this ties in with the question asked by the trial panel earlier this morning,
Apologies, Your Honor. We would request redaction to that from the public transcript as well.
Your Honour, in relation to that, firstly, I apologise for the reference to the name of the witness, but in relation to the other names, last week, the SPO made their position clear on open source material. Mr. Hallin said it, absolutely clear, that they will not seek redactions on any information that is available on open source material. I can take the trial panel back to the transcript if the trial panel wishes.
Debate. Do you have a response?
Yes, Your Honor. What's identifying here is that this is a journalist and he's reading from the contents of a particular article. The names of the people Mr. Reese is naming now, he can do in a different context, but with the frame that he's selected now, that's what is identifying.
I mean, Mr. Rees, just on this, again, we'll ask you to focus. We understand the underlying nature of your submissions. I don't think it is of assistance to us for you to read out the material that we have in our possession or to name other individuals for the reasons that have been explained a moment ago. So if I can ask you again to please focus your submission on the merit, but maybe before I do that, I will simply ask the prosecution to clarify whether, in response to your invitation, whether that's part of their case that the proposed witness is one of the individuals alleged to have been incited by the accused. Mr. Halling?
No. The way that the summary in the annex to filing 299 mentions the paragraphs of the indictment that we are using this witness for. Paragraph 47.4, which is mentioned by the Gucati defense, is not in that list. I would also note that this person was interviewed as a witness and not as a suspect. Thank you.
I think the point that I understood Mr. Rees to be raising is not whether there was an indication of your proposed witness having committed an offense, but whether it was part of your case that he had been incited by the conduct that you attribute to either or both of the accused. That was my understanding of their submissions.
Thank you, Your Honor. I'll clarify. We are submitting that this person is incited by the conduct of the accused, but as you correctly pointed out, we are not alleging that any crimes were committed by this person.
So, Mr. Rees, you have your answer. Can we have your position on the application?
So I'm grateful on clarification that there is nothing criminal
For the record, I have signed redaction orders as previously mentioned in 2 instances.
I have a few more questions for you, Mr. Halling, and I think they, you've answered probably most of them at an earlier point today in the submissions. May we take it that the official note taken of the proposed witness, which you refer in footnote 9, I believe, of your application, was indeed disclosed to the defense? Is that understanding correct?
It is, Your Honor. Just while I have the floor, just to make sure that there's no misapprehension by the Gucati defense, we are using this as incriminating evidence in the case, and we just didn't want to make sure there was any misunderstanding of what we were submitting and what we were not submitting. But I wanted to clarify that independently of your question.
I think the way I have understood Mr. Rees to formulate his submission, he will suggest, as I understand, that there's a conflict in your position between what you say your witness has done and what you allege the accused have done. But I'll leave that to you to address if and when.
There's no conflict in the sense that Mr. Halling has rightly clarified. It suggested that the interview of the witness be added to the exhibit list. I don't understand the purpose of that when the prosecution are proposing to call the witness to give evidence orally. I don't understand and there's no justification given for the admission of his interview into the exhibit list when they are proposing to call him to give oral evidence.
Thank you. And Mr. Rees, may we ask you again to be mindful of the use of names here, but may I just ask Mr. Cadman as well if he shares the position of the Gucati defense that there is no objection to the proposed witness being added to the prosecution list. I should have done that before, and I apologize, Mr. Cadman.
Your Honour, between us we had discussed seeking the clarification. Now the clarification has been made, we would support the position of Mr. Rees that we do not object.
We're grateful for that indication. Mr. Halling, briefly, two matters of clarification. I think Mr. Rees committed the same mistake as I did in relation to the date of the interview. Can you confirm that the date of the interview of the proposed witness is indeed the 25th of August of 2021 and not the 25th of March, as I think appears on the top of the record in question?
You are correct, Your Honor. Given the mistake, we'll file a corrected transcript on this.
We're grateful for that. Two outstanding issues, I think one that you have made clear, there is no plan, as we understand at this stage, for you to seek protective measures. Is that right?
That's correct, Your Honor.
And lastly, but perhaps most importantly, may we take it that you have conducted a review of your records right now with a view to ensure that all material relevant to this particular individual, should leave be granted, has been disclosed to the defense?
Yes, Your Honor. Everything that we are aware of related to this witness.
Thank you. I see Mr. Cadman wanting the floor. Yes.
The only additional question which Your Honour has now addressed, and obviously we anticipate the SBO doing a proper search as to any previous interaction with this particular witness. That was going to be my question. Is this the first time that this witness has been spoken to by the SBO, or are there previous? Because from the material that has been disclosed, it would indicate that there have been prior interactions with this witness. I think we're entitled to know what those interactions were and whether a prior statement or prior record of interview was ever taken with this witness.
Well, there's at least one other that we know of, Mr. Cadman. It's the note that the prosecution has referred to of th of January of 2000. So that would be the other one, and I'm sure that the prosecution will be mindful in reviewing their records to disclose anything that would constitute a statement of the witness if they haven't done that already. But I'm grateful, Mr. Cadman.
Mr. Halling, just to clarify, I didn't hear your response to the objection from the Gucati defence to the admission of the interview transcript to the exhibit list. What's your position on that?
Yes, Your Honor. We are systematically adding all interview transcripts and declarations to our exhibit list. This is just something that we do because of the vagaries of criminal proceedings. We don't know when we might want to tender those statements into admission. I can tell the trial panel now there is no intention to use rules 153 or 154 in relation to that statement. If the witness appears as we expect and gives the expected testimony, we will not tender that statement.
So could I just clarify what's the purpose of adding it to the exhibit list?
If, for instance, there is, I mean, this is just speaking hypothetically, if there were a situation where it might become apparent that this witness becomes subject to interference, such that Rule 155 may become engaged down the line if subsequent facts dictated as much, we would need to add it to the list of evidence in order to tender it under something like that provision. It is something we are doing with all of the statements and declarations of our witnesses in this case. It doesn't mean that we are currently tendering them or planning to tender them, but it is to help put the defense on notice that depending on how the trial unfolds, that this is a potential exhibit of the SPO.
Thank you, Mr. Helling. No further questions. Thank you.
All right, now let's move on to the next topic, which is the date for the opening of the SPO case and the opening statements. Last week, I indicated that we plan to open the case on Thursday, the 7th of October, 2021, and hear on that day the SPO's opening statement. The defense also indicated last week that they do not intend to make an opening statement immediately after the prosecution. Both defense teams indicated that, but they are considering making one before any defense case. Mr. Prosecutor, does the 7th of October work for you to open your case and make your opening statement?
It does, Your Honor.
Mr. Reese, Mr. Cadman, do you stand by your indication that you do not wish to make an opening statement immediately after the SPO, and would October 7th work for you for the SPO to make its opening statement? Mr. Reese?
Yes, thank you, Your Honor.
Mr. Cadman?
Yes, Your Honor.
All right, before I ask the SPO about the length of your opening statement, Mr. Reese and Mr. Cadman, can you indicate whether you want the prosecution to read out the entire indictment at the opening, or only the part on the charges, which are paragraphs 47 and 48 of the indictment? Mr. Reese?
We think the entire indictment should be read out in public. The trial is a public trial. The indictment as a whole spells out the allegations and how the SPO set them out.
Mr. Cadman?
Your Honor, I would support that.
So, Mr. Prosecutor, you now know what you're going to have to add to your opening statement. How long do you think your opening statement will last, all told?
Thank you, Your Honor. The SPO envisages an opening statement of around 2 to 3 sessions, which would be about 4 hours, in which audio-visual materials would be played and the case would be presented in all necessary context. The SPO can present its opening statement in whatever time frame the trial panel requires.
Do you believe we can finish this opening statement on within the day of October 7th?
With the caveat that the entire indictment is now going to be read, it will be close, but I think it is possible.
Okay. Did you have something? Can you give the defense? You're going to use some proposed exhibits. Then I take it in your opening.
That's correct.
And can you give the defense and the panel 24-hour notice of which exhibits or which proposed exhibits you want to use for this purpose, and with relevant time for if it relates to a video?
We can, Your Honor, just to make sure that I understand the direction. The notice of the relevant time in relation to the video, you mean the timestamps of the video?
Yes.
Yes, we can do this.
Thank you. The panel will issue an order in this regard later today. This leads us to the next point, which is the time available and a provisional schedule for the SPO case. I note that the SPO time estimate for its 2 witnesses is 15 hours of direct examination. That is 10 hours for witness 04841 and 5 hours for witness 04842. And I'm using that number today just for convenience. For the additional witnesses, were the panel to grant the request, the estimate is 3 hours of direct examination. Last week, I indicated that we plan to hear evidence in the weeks of 18 and 25 October, which we would, in all possibility, the possibility is for 4 days of each of those weeks of testimony. In what order do you intend to call your witnesses, Mr. Prosecutor, and how many days do you envisage their direct examination would take, assuming that we will be sitting for 4 days a week from 9:30 to 4 p.m. And is it an option for you to call witness 4866, the new named witness, last if the panel grants your request?
Thank you, Your Honor. You've correctly set out the estimates. There still are estimates for all of these witnesses. W04841 is a Rule 154 witness, and the others would be entirely viva voce. If you add up the examination estimates, you get about 4 days of direct examination, given the sitting schedule indicated previously by the trial panel. So that would be our estimate. The order that we were envisaging was to call 4841, 4866, and 4842 in that order. Your Honor has just indicated a possible different order where 4866 would appear last, and it's as the trial panel wishes on this.
The reason we listed them, we were suggesting them to be listed last, was because of the late date of naming him. It would give the defense more time to contemplate his projected testimony.
Yes. In a longer trial, this is a bigger issue. When
Yeah.
all 3 witnesses are basically appearing contemporaneously, we have no problem with proceeding as the trial panel indicates.
All right, thank you. Mr. Reese, last week you offered a maximum estimate of 12 days for cross-examining the 2 initial witnesses of the SPO. How would this estimate change if the panel granted your request to add a 3rd witness, or not your request, granted the request for adding a 3rd witness? And taking into consideration the answer of the prosecution and the availability of the 8 hearing days I mentioned, how far do you think we can get with your cross-examination? Ideally, we wanted to try to finish the prosecution's case in those 2 weeks that we have available to us. So we ask your estimate of that wish on our part.
Additional cross-examination in relation to the 3rd proposed witness, for my part, will be relatively short, perhaps no more than a session. So it doesn't greatly alter the time estimates that I provided last week. I did make it clear that I was being pessimistic. I was erring on the worst case scenario. I nevertheless do think, although we can certainly try to complete the prosecution case by the end of that 2nd week, at the end of October, I still think that's unlikely.
Nothing much to add to that. Just to re-emphasise the point that was made last week upon the invitation of the trial panel, that much of the cross-examination is not going to be a question of Mr. Reese asking a number of questions and me standing up and asking. We're going to try and combine as much as we can through cross-examination, but I do share Mr. Reese's pessimism in getting it done within that 2-week slot.
Thank you. We continue to encourage you to continue to have discussions about joining your cross-examination as much as possible, and we realize that it's not always a perfect scenario. Thanks.
Your Honor, is it possible to respond on the defense estimates on this point
Certainly.
before continuing?
Certainly it is.
Thank you. The defense are entitled to a fair opportunity to question SPO witnesses, but it is noted that, as the Haradinaj defense just noted, the defense teams have very similar interests in this case, and the examination limits set should reflect that. And 2, the estimates given last week, 7 days for 4841, 5 days for 4842, are clearly excessive. Having examination limits is meaningless if parties are advancing such a disproportionate amount of time to examine witnesses. In this regard, we note the terms of Rule 143.4, which gives the presiding judge the authority to exercise control over questioning, to make the questioning and presentation effective for the ascertainment of the truth, avoid repetition, undue consumption of time and resources, and avoid harassment or intimidation of witnesses. We ask that reasonable time limits be set such that the examination of the 3 SPO witnesses finishes by the end of October in that envisaged time frame. Thank you.
Thank you. part of the process of deciding whether to impose those limits involves hearing everyone's estimates so that we can start taking into consideration what's being requested. And we will seriously consider everything and that has been stated here and make a decision ourselves on that and share it with you as soon as possible.
Can I respond quickly to that, Your Honor?
Yes,
Very
you don't have to do much. You said it was your pessimistic estimate, and I took it as that.
I'm grateful.
Yeah.
And it was pessimistic, trying to come up with erring on the side of caution, but nevertheless realistic approach as to the cross-examination of two witnesses, one of whom produces a schedule that has 9 columns, approximately 400 rows of material that has not been disclosed to the defence. And the only thing I can do is propose, I'm conscious that there is still an outstanding motion, and we may not have to deal with it at trial because the admissibility of that is in dispute, one issue of which is the difficulty the defence are posed in trying to challenge it in those circumstances. But if it goes in, I will have to go through that schedule line by line, column by column with that witness.
Thank you. And we're conscious of that. You brought it up last week, and we do understand your objection, and it's noted. Now I want to ask the parties an estimate for finishing the trial. As you know, Rule 118 requires the panel to set a target date for closing the entire case. As discussed last week, ideally, and I think everyone agreed ideally, this would happen before the end of the year. Would mid-December, which is the end of the year for the court, be a realistic provisional date for the time being? Of course, this can be adjusted as necessary. Mr. Howling?
Your Honor, at least as regards the SPO's evidence presentation, and depending on questioning and the bar table request, we should be able to finish by the end of October. And so that would give all of November and mid-December for examination of defense evidence.
All right. Thank you. Mr. Rees? I take it you agree?
My position remains the same as it was last week, Your Honor.
And yours? Same. All right. Thank you. We will issue an oral order in this regard, setting out all those dates. We've reached the end of our agenda as sent to you. The panel wants to address an issue in relation to the SPO submission on the classification of exhibits, which is an extra item. Judge Matreau will handle those questions. You have the floor.
Thank you, Judge Smith. Very briefly, and the question will be for the defense primarily, but on the 6th of September of 2021, the SPO filed an application for classification of proposed exhibits, and the SPO identifies 3 categories of information in relation to which redaction is being sought. It includes, number 1, image of content of material said to have been unlawfully disclosed by the accused. On the number 2, names of staff of the SPO other than the 2 proposed witnesses that will be called by the SPO. And on the number 3, letters to and from organization in respect of investigative cooperation. Now, briefly before we hear the defense, these categories, Mr. Rees and Cadman, do seem prima facie to be reasonable to the extent that the material has been given to you without those redactions, of course, and that redaction are being sought exclusively in relation to the general public, so that it would appear, at least prima facie, that they would not interfere with your ability to fulfill your mandate and responsibilities effectively. Of course, we are mindful that the proof will be in the pudding, so to say, and that it's the implementation in practice of these proposed redactions that might be problematic. So the proposal that we would have for you is for the defense to discuss with the prosecution the nature, scope, / extent of the proposed redactions that would be made on the basis of that application, with a view to try to reach an agreement between the party as to what could be redacted, and to notify the chamber or the panel whether such an agreement has been reached, and if not, the extent to which there remains a disagreement. Would that be agreeable as a matter of process to you, Mr. Rees, and you, Mr. Cadman?
Certainly content to try to resolve matters inter partes with the SPO, and we will do our best.
Absolutely, Your Honour.
We're grateful for that indication. May we take it, Mr. Harling, that you share the warm and good spirit of cooperation on that issue?
Always, Your Honor.
Thank you.
Well, the panel will indeed order the parties to discuss this issue, inter-party, together to endeavor to come up with an agreement, and to inform the panel of such agreement of any unresolved issues by the 20th of September. And the panel will issue an oral order in this regard at the end of the conference with a review to expedite the matter. So we will be taking a, 20 minutes? Yes. A 20-minute break in order to consider the oral orders and get them in order for you. Just make it be back here at 12:30, and we will try to be ready to proceed and then wrap up for today. Case, we are adjourned.
All rise. Tavares.
The panel issues the following oral orders. First oral order, having carefully considered the arguments raised by all parties in relation to the SPO request to add one witness to its witness list, and noting that the defense did not object to this, the panel hereby grants the request. The decision on adding the 29 connected items to the SPO exhibit list will be decided by the panel in due course after receiving the SPO request for adding revised transcripts to its exhibit list as ordered on September 2, 2021. Pursuant to Rule 118(1)A, the panel determines that the SPO may call 3 witnesses for the presentation of its case, namely Witness 4841, Witness 4842, and Witness 4866. The panel further orders the SPO to call Witness 4866 as their last witness so as to allow ample time for the defense to prepare. The SPO shall file on 1 October 2021 a list of its witnesses in the order in which they will be called and in compliance with the panel's future order on the conduct of proceedings to be issued shortly. This concludes this oral order. The second oral order. After having heard the parties and pursuant to Rule 118 sub 3, the panel sets the date of the opening of the case to 7 October 2021. Further to Rule 124, subparagraph 2, and the submissions of the defense, on the occasion of the opening of the case, the SPO shall read the corrected version of the indictment as filed on 5 January 2021. The SPO shall deliver its opening statement on 7 October 2021 and shall endeavor to finish such statement in one hearing day. The SPO shall also provide to the panel and the defense, 24 hours before the opening of the case, a list of proposed exhibits, if any, on which it intends to rely during the opening statement, indicating the relevant timestamp for any video to be played. The presentation of the SPO case shall start on 18 October 2021. The SPO shall endeavor to finalize its direct examination of its 3 witnesses within 4 hearing days. The panel shall not set a time limit for the defense cross-examination of the SPO witnesses, but reserves the possibility of doing so should this be necessary to avoid repetition and guarantee the expeditiousness of the proceedings. Throughout the SPO case, the parties shall comply with the requirements set out in the panel's future order on the conduct of proceedings to be issued shortly. Furthermore, having heard the parties, the panel sets as target date for the closing of the SPO case the 9th of November 2021. The panel also sets as target date for the closing of the entire case the 17th of December 2021. The latter 2 dates may be amended as the trial unfolds, and this concludes this oral order. I'll say it again. Apparently, I misstated the date of the corrected version of the indictment. It's correctly stated as July 5th, 2021. That concludes the second oral order. The third oral order, the panel orders the parties to discuss the issues pertaining to the classification of exhibits in the SBO bar table request, to endeavor to reach an agreement regarding the nature and scope of the proposed redactions. By September 20, 2021, the parties shall inform the panel of any agreement reached on this issue and of unresolved matters, if any. This concludes this oral order. The fourth oral order, the panel orders the parties to file further written submissions, if they so wish, on the elements of offenses and modes of liability, in particular on the specific questions related to the offense of obstruction and the relationship between the modes of liability charged, which were deferred during the proceedings. In the real-time transcript, that's page 24, lines 24 to 25 to page 25, lines 1 to 6, page 25, lines 1 to 15, page 42, lines 16 to 18, page 43, lines 20 to 21. The parties are instructed not to repeat submissions made during the hearing unless strictly necessary for the logic of the argument. Submissions shall be filed by 30 September 2021. This concludes the fourth oral order, and this concludes our proceedings for today. Mr. Rees, did you have something?
Please, purely administrative matter, but it would assist with planning for the forthcoming trial. If we were to know, firstly, in relation to that 2-week period at the end of October, which day of each of those 2 weeks we will not be sitting on?
Right now, our plan would be that we would meet Monday through Thursday, not meeting on Friday, both weeks. And I suppose the only reason we do it that way, well, there's many reasons, but we could potentially go into part of Friday if absolutely necessary to finish something up. We leave that open. But our primary thoughts are Monday through Thursday.
I'm grateful. And then in relation to the period thereafter, the 2 days a week that we will have available to us, do we have an indication at this stage which 2 days of the week that is likely to be, or will that?
Yes, in consultation between me and the presiding judge in trial panel 1, we have mapped out November and December because there's some times when people aren't available also. So we will endeavor to get that to you as soon as possible so everyone can start making plans accordingly. There are some weeks where we might get 2 days, and I think there's one other week where we might get 4 full days. So, and that would be in December, if necessary. So we will try to get that finalized and submitted to everybody so you have an idea of where we're going with these days. It's complicated with 2 panels using this room and fitting in other, especially since the pretrial judge has to have it available to him on a regular basis too. So
Thank you.
We'll get that to you as soon as possible. Thank you very much for your attendance today. Once again, thank you for your good preparation, for your candor, for your courtesy. We appreciate all of that, and we'll be seeing you all again soon. This hearing is adjourned.
All rise.